In here from the Warren County Bar on behalf of the appellants, and I'd ask to reserve 3 minutes for rebuttal,
3 minutes,
please.
yes, sir.
We're here today asking this court, we're here today on an appeal of a ruling from the Warren County Chancery Court denying injunctive relief to the appellants, and are requesting this court to overrule that ruling and remand it to the Chancery Court for entry of an order providing for that injunctive relief against the town of Morrison from harassing or otherwise interfering with their property rights. And in this matter, the procedural history encapsulates most of the facts that are pertinent. And in 2017, February of 17, my clients were cited into the municipal court for the town of Morrison for zoning ordinance violations. This had to do with overgrown trees and many acres. And upon a hearing in which both sides were represented by counsel, the issue of whether they were ever actually in the town of Morrison was raised. And after some argument, the municipal court found that no, they were never actually properly annexed and dismissed the citations for want of jurisdiction. That order became final when the town of Morrison did not avail themselves of their right to appeal that matter to the Circuit Court of Warren County per the statutes.
Now, is it fair to say that at that time the town only relied upon what I'm going to refer to as Ordinance 03 in that hearing?
That's correct, Your Honor.
Okay.
And what precipitated that was actually prior to the hearing a records request for all zoning or annexation ordinances pertaining to the property, and both sides at that time were under the belief that that was the only ordinance.
All right. And is it correct that up until this point your clients had been paying property taxes to the town of Morrison?
I can testify. I can say that that is true of the first three listed. I was not representing the others at the time.
Some of the plaintiffs, okay.
Yes, Your Honor.
That's fair.
Yes, Your Honor.
Thank you.
And so after that, about 2.5 years later, the town of Morrison files a declaratory judgment action. And after briefing and hearing on the issues, Judge Johnson, sitting by interchange, decided that issue preclusion or collateral estoppel applies to the issue of whether the appellants were ever annexed into the town of Morrison. Morrison then files appeal to this court, and 3 months later files a notice of voluntary dismissal of that appeal. So I think what Your Honor was maybe thinking of when you asked that question is an issue of acquiescence or something like that. We would argue all those matters were waived at the time that they dismissed their appeal in that matter. In the interim, prior to dismissing that appeal, Morrison finds the new ordinance that we're talking about, 0102, that appear to properly annex the property. But they decided nonetheless to rely on those and dismiss the appeal on that matter. They continue to send tax notices, and so we file a petition for the injunction. And after hearing Judge Ash, sitting by interchange, determined that the only issue decided in those prior hearings was whether 0103 annexed the property, not whether they're annexed as a whole. And so, Your Honor, we argue two things here. Is one, that the Chancery Court erred in narrowing the issues that were decided. And there's two reasons. For one, they ignored the plain language of the orders. And I quote from the municipal court order: because defendant's property was never annexed, this court does not have jurisdiction over the property. Same finding in the Chancery Court first case, the declaratory judgment action. Quote, in finding the issue in this case where the subject property's annexed was previously decided, and they dismissed it due to collateral estoppel. Secondly, it ignores the logic of what was happening in the municipal court. This was not a declaratory judgment, which I would agree that municipal court doesn't have jurisdiction to hear a petition for declaratory judgment. This was an issue of them citing my clients into the municipal court for zoning ordinance violations. And it is inherent that the municipal court has to determine whether these people are even in the town of Morrison and whether they have jurisdiction, not whether a single ordinance was validly passed, but whether they had jurisdiction over them at all. And so we argue that the Chancery Court erred in narrowing that issue. What we're dealing with here, I believe, and it takes a little bit of mental gymnastics, is an issue of double collateral estoppel. So we would argue that not only is Morrison, the town of Morrison, prevented from relitigating the issue of whether they were properly annexed, they're also prevented from relitigating the issue of whether collateral estoppel applies to that issue, because they did not appeal that ruling from the Chancery Court.
You mean from the municipal court?
They did not
There
appeal
was-
from the municipal court, and they dismissed their appeal from the holding that it was collateral estoppel. So we would argue that they're also collaterally estopped from arguing that collateral estoppel doesn't apply.
Let's go back to the municipal court action. I'm of the belief, but you're welcome to educate me, that the municipal court's jurisdiction is limited to determining whether a person has violated a municipal ordinance, as distinguished from whether an area has been annexed. Is that a fair distinction to make? And did you dispute that the municipal court does not have the jurisdiction to determine whether an area has been annexed?
That, as I said, Your Honor, both sides were represented by counsel, and that issue was decided by the municipal court and was not appealed. I think it's inherent in any court's jurisdiction, and I'd give the example if they cited somebody from South Dakota in there for violating their weed ordinance in the town of Morrison. I think they can look at the map and say, I don't think we can make a ruling on this and dismiss it because they're not even in our jurisdiction. So I think any court has to determine whether there's jurisdiction for them to decide those claims and enforce those ordinances.
Well, determining whether it appears that a piece of property is within the town's area is one thing, but determining whether an annexation has properly occurred, wouldn't that be a different legal issue? And isn't there a question of whether the municipal court had subject matter jurisdiction to make that type of a determination?
Well, the first thing I would say is that by not appealing municipal court order, that issue is waived once the order went final.
But isn't subject matter jurisdiction something that can be raised at any time by anyone, including a court such as this court?
I believe that's correct, Your Honor. But again, I don't know how the municipal court is able to determine their power to enforce an ordinance against somebody without knowing whether or not they're in the town of Morrison's boundaries. Mm-hmm. You know, the town of Morrison also could have appealed that issue to this court from the Chancery Court and failed to do so there as well. So here we are, third bite at the apple, and we would also argue that the Chancery Court erred in allowing for new evidence to be introduced. As it was said, prior to the dismissal of their appeal, the town of Morrison found this new ordinance, which had not been provided or presented to any court prior to that. And we believe that this is an issue of first impression in Tennessee as it pertains to collateral estoppel. But its sister doctrine, res judicata, has dealt with the issue in Jackson versus Smith, Tennessee Supreme Court case in 2012, that held that res judicata applied to a grandmother who was pleading a change in law based on the same facts. The statute was passed not long after she had a hearing, and this new statute gave a presumption that there needed to be a relationship between the deceased, a parent of a deceased parent, the grandmother. There was a new statute that said that there was a rebuttable presumption as to the relationship with the child, and the court said, nope, that was the law at the time, and it was decided on the facts presented at the time. And they said in that case, and I quote, if we have decided to change in the law occurring after does not give rise to exception for res judicata, how can we say that failure to present law that did exist at the time of the decision is equitable and requires relitigation? Multiple federal district courts we've cited in our brief, and I won't go through them all, have addressed the issue, the 1st, 8th, 10th circuits, and held that newly discovered evidence is not admissible to relitigate or is an exception to claim preclusion if the evidence is reasonably discoverable in the prior adjudications. At all times, the town of Morrison held this evidence. It's not a situation where we could have looked in Westlaw or anything like that. It was in their offices. It's not publicly available. A public records request was requested, and this is what was provided. So I don't think that there's any argument for excusable neglect. They actually possess the evidence. And as our Supreme Court recently stated, if citizens must turn square corners when they deal with the government, it cannot be too much to expect the government to turn square corners when it deals with them. That was in a recent case in May of 22, the recipient final expunction order in McNairy City Circuit Court. With my remaining time, I'd just like to address one of the cases that they cite in their brief that argues the Bridgestone case, which I believe Your Honor drafted, and that case is entirely distinguishable from the current case.
It doesn't seem like a good fit because it was only after the ruling of this court that plaintiffs discovered that they could not proceed in Mexico.
Correct. The issue in that was whether they actually had an opportunity to litigate. In this instance, they've had more than one opportunity to litigate. They've failed to appeal those properly, appeal those issues, and so we're 5 years down the line, and on our third case here, and now before the Court of Appeals, before they now argue new evidence to say, hey, we were wrong. I think that creates a really dangerous precedent to say that you can just come back with new evidence that existed in your control at the time. It incentivizes a party not to prepare necessarily or to withhold some evidence as insurance against a bad ruling so they can come back and say, wait, let's try this again. I've got new evidence to present, and let's see if we can win this time. So, Your Honors, I respectfully ask to overrule the ruling of the Chancery Court and grant that injunction. Thank you.
Thank you, sir. We'll hear from the appellee. Mr. Luna, good morning.
Good morning, Your Honors. Nathan Luna, Rutherford County Bar. It's a very important fact to remember the parties agree that the property was properly annexed under ordinance number 01-01. But that ordinance also covers additional properties that are not parties to this action. Ordinance number 01-01 covers 396 plus or minus acres, which is additional land in addition to the appellant's property. So collateral estoppel does not apply. First off, these are two different issues. The parties are essentially litigating two different cases here. There's the idea that ordinance number 01-03 and the ruling from the municipal court completely removes any opportunity for annexation of those properties. And then there's the idea that ordinance number 01-01 does properly annex those properties. So when this municipal court made this ruling, one of our arguments here as an issue to bring up is that the municipal court did not have subject matter jurisdiction to make a declaration that ordinance number 01-03 or any ordinance is unlawful or improper. And I believe the appellees agree that if that Declaratory Judgment Act does not apply to municipal court. The municipal court did have an enforcement action to determine whether the weeds were grown too high based on the ordinance, and in that enforcement action, they made a declaratory judgment. It doesn't matter if it began as an enforcement action. The fact is, in the ruling, a declaratory judgment was made, and that declaration was that ordinance number 01-03 does not properly annex the appellant's property. And if you look at the municipal court...
Did the municipal court have the jurisdiction to make that determination as distinguished from whether or not a piece of property is within the municipality?
I believe the municipal court has the authority to determine and make a ruling. We're dismissing, for example, we're dismissing this case for overgrown weeds. That's an enforcement action, and they made a ruling on that enforcement action. But they don't have the jurisdiction to declare that an ordinance is invalid, even if their reasoning for making the enforcement ruling is because of that. And that's where it would be on the town of Morrison at that point to appeal to a court that does have subject matter jurisdiction, like a chancery court, to make that determination that that was an improper ruling and a ruling should have been made on annexation at the chancery court level. And this is new water. So there's not a lot of case law on this, so that's kind of the way that the town looks at it as far as what should have been done.
Counsel, is an appeal from municipal court to circuit court?
I'm not sure. The 10-day appeal period is to, I'm going to assume circuit court, yes, sir.
Thank you.
If you say it is, then yes, sir.
Not making any ruling at this point in time. I was simply inquiring. Thank you.
And also, even if collateral estoppel does apply, the Bridgestone case that was authored, the facts are different, but the law is not, and the statement is that collateral estoppel, even if it does not apply, there is still relitigation permitted to avoid the inequitable administration of the laws. So in this case, you have ordinance number 01-01 that annexes properly, is agreed on in the record, properly annexes the appellant's property. Properly annexes the appellant's property. Yet a ruling that would uphold the municipal court's order as interpreted by the appellees would subject other property owners under that ordinance.
Well, but, I mean, would it? I mean, I guess you couldn't you carve out the ones here that are challenging it?
Not here. I don't believe you could. I believe that,
I mean, if you had another property owner that came up later and said, wait a minute, look what happened in this case. They determined that the city was bound by, or the town was bound by the prior precedent here. I'm sure the town would come back and say, well, wait, you weren't a party to this, and we are now raising 01 and 02. They're valid. They've not been litigated in any sense, and under these two ordinance, you are annexed. I mean, I think that would be the town's response.
yes.
So, I mean, you may have a hole in your annexation plan because of these property owners being successful in court, but, you know, necessarily inure to the benefit of every property owner that had been annexed.
Okay. And going back to the town's failure to locate these new ordinances, I'm sure that's the million-dollar question, and it's a very simple answer. The town of Morrison had very poor record keeping. Very poor record keeping.
And I'm curious, how do people, where are these ordinances available for normal citizens to find out what the law is?
Normally, you would contact the city recorder up at the town of Morrison and ask for a copy of any ordinances related to this, and the city recorder would go through their books and
You'd have to leaf through the actual hard copies?
yes, Your Honor, and I believe it's in the record that counsel for the town of Morrison actually took the books home going back to 1984 to look through everything. It's poor. It's just poor record keeping, which that part is inexcusable, quite frankly, when it's requested. And but the reason that the Chancery case was dismissed is because these new ordinances were discovered, and it's important to show also on the record that as soon as they were discovered, they were turned over to the appellants as soon as they were discovered, and therefore traveling under 01-01, dismissing the appeal on 01-03.
I'm assuming under state law, with an annexation, property owners would have to get notice.
Yes, sir.
Is there anything in the record that shows what notices these property owners received of the annexation?
Under both 01-01 and 01-03, the record does indicate that notice was properly given. I believe it has to be publicized in the local paper and given a date as to when they're going to have a public hearing on it. So the issue with 01-03, and the reason that was considered invalid, was because on the second reading, they didn't go to the second reading before voting it in. They voted it in during the special set public hearing. instead of adjourning the public hearing and then voting at the at a special set meeting, they voted during the special set hearing, and it was a major procedural flaw in the way that they did that under 01-03.
Now, does 02 apply at all, or is it just 01?
It's 01 and 02. 01 is the actual language of the ordinance. 02 is the adopting of the map. But 01 is the language of the ordinance. And next, we would get into acquiescence, King versus City of Watertown. First, in response to the appellate's argument that that has been waived, we would argue it's not been waived because ordinance number 01-01 has never been challenged in any court. It is actually agreed upon to be valid. And ordinance number 01-01 is what the town is
Now, you
relying
say
on.
it's agreed upon to be valid.
Yes, the record would show that the parties agreed in trial that ordinance number 01-01 properly annexed the appellant's property. That's a very important fact.
Right, and what's not agreed upon is whether the town can impose the taxes retroactively or for the period since the annexation.
Or the period going forward. The argument the appellants are making is that the municipal court's ruling on number 01-03, because it couldn't be on the other ordinances because nobody knew those other ordinances were there. So the municipal court's ruling on 01-03 effectively precludes the town of Morrison from making any argument about annexation of those properties in the past.
So even though these properties were properly annexed under 01 several years ago,
2001, yes, sir.
the argument is they can never be taxed under that annexation, and the town would have to do a re-annexation of a territory they've already annexed.
Correct, and the law has changed on annexation. You can only annex with consent of the owners now. That statute is different than it was back then, and obviously,
That's not gonna happen.
that's not going to happen. So that's what makes this so important. Is
Did some or all of these property owners pay taxes to the town of Morrison?
all of them up. In fact,
Up
I believe.
Up until the litigation.
In fact, I believe that the Odoms and the Odom Revocable Living Trust, I believe they even were paying property taxes even after the litigation began. Yes, sir. But it's been, I believe, since 2017 since the other appellants had paid their property taxes. And we would argue where we're getting with that is that there is acquiescence. There's a case, King versus City of Watertown. It's an unreported case, and it's in my brief. And in King of City of Watertown, the court says, we are of the opinion that acquiescence over the long period of time in the location of the municipal boundary by both the municipality and the inhabitants of the municipality, where municipal action improvements have been done under the assumption that the property is located within the boundary, will support the conclusion that the boundaries acquiesced in are the true boundaries. And for 16 years, the appellants were paying their property taxes, and it's very important on this Watertown case too that says plaintiffs acquiesced in their property being a part of the City of Watertown until such time as it no longer suited their purposes. The appellants in this case acquiesced to being part of the town of Morrison until they got cited in for not following the town of Morrison's municipal ordinances. Then it was no longer convenient to be a part of the town of Morrison because they were going to be subjected to the laws of the town of Morrison. And the next issue that we have brought up here is we're asking that the trial court's ruling on equitable estoppel be reversed. The trial court used the doctrine of equitable estoppel to make a ruling that the town of Morrison could not collect taxes on any of the appellant's properties prior to 2022 and any delinquent taxes, and 2022 going forward could start doing regular tax collection. We would argue that equitable estoppel requires misconduct, and misconduct does not meet the standard here under what has been determined to be equitable estoppel. And the case that says the doctrine of equitable estoppel applies only when the defendant engages in misconduct is B&B Enterprises of Wilson County versus City of Lebanon, and it's on page 14 of my brief. And that's quoting another Tennessee Supreme Court case as well. And this doctrine's only been applied in situations where a defendant has promised not to assert a statute of limitations defense, a defendant has promised to pay the plaintiff's claim without requiring the plaintiff to initiate litigation, and a defendant has promised to settle a plaintiff's claim once another action between the defendant and a third party is resolved. So I believe those are in terms of case types that are different than this one, but the standard still shows that equitable estoppel applies when there is misconduct. In this case, the record is clear that there is negligent record keeping and very poor record keeping, but there is no allegation in the record at all that shows there was any intentional, and this is a very important part as well, there's no allegation in the record that there was any intentional conduct to keep these laws from the appellants, to keep the appellants in court.
Your client was sending tax notices.
Yes, sir.
So it's not like, hey, surprise, you've been annexed.
Yes, sir. And also, Town of Morrison's counsel and the appellant's counsel stayed in communication. And again, I believe the record shows that once 0101 was discovered, it was immediately sent to counsel for the appellants. And so I believe this case would be distinguishable if there was proof that there was some intentional misconduct or intentional keeping away from the appellants. But in this case, it is small town, poor record keeping.
Yeah, poor record keeping plus poor litigation strategy.
Absolutely.
Because I'm assuming that the appellants are going to come up and say, well, yes, we got tax notices, but we got a very favorable ruling in municipal court, and then in a later proceeding, it's like, why would we pay them in light of the court, their behavior in court? But I see where we're headed here. So.
Yeah, that's what makes it a mess is 01-03 was suspect. And again, why in the world did they have two different ordinances on the same piece of property, which is also problematic? And you could probably see Town of Morrison counsel's frustration showing through in some of his briefs in the record as to why that was. But at the end of the day, everything was done in good faith, and a good faith effort was made to do what we needed to do.
All right. Thank you very much. Thank you, Mr. Luna. Mr. Galligan.
Your Honors, I'd like to briefly again address the issue of acquiescence. The discovery of the new ordinances did not bring up the issue of acquiescence for the first time. That was actually pled in the first Chancery Court case. So at the moment that they dismissed their appeal from that case, they waived any argument as to acquiescence. Further, I would say that the case they're relying upon, King versus City of Watertown, has no precedential effect. It's a 1986 case that in its 36 years history has never been cited. And in fact, this court more recently in 2010 talked about acquiescence involving government entities in Gentry versus McCain, and said that acquiescence applies to boundary disputes between private landowners, sure, but they refused to extend that to a dispute between the government entity and a private landowner over the right-of-way. So they said, we're not addressing it and we're not extending it. They didn't cite King versus City of Watertown in that instance. But again, we'd argue that it's waived at this point. And I'd also like to point out a quote from this court, in the court, Liberty Mutual versus FAG Bearings Corp. And in discussing collateral estoppel, they say the doctrine of collateral estoppel represents an informed choice that the occasional permanent encapsulation of a wrong result is a price worth paying to promote the worthy goals of ending disputes and avoiding repetitive litigation. We didn't know at the time it was a wrong result, of course. We found out prior to, though I must point out, prior to the town of Morrison dismissing their appeal from the first Chancery Court action. Again, they didn't, once they found that out, they did, I agree with counsel, provide that immediately to opposing counsel. But what they did not do is file a Rule 60 motion in the Chancery Court. And what they did not do is ask for further relief from this court while that appeal was pending to introduce new evidence. They simply dismissed it and said, hey, that wasn't the issue. But that flies again against the plain language of the orders of both courts, and we would argue that they're collaterally estopped from relitigating the issue one more time.
All right, thank you very much. We
Thank you, Your Honors.
appreciate your arguments. We'll take the matter under advisement. Call the next case.